I have something I thought I might never have again on this channel. A Sarah Boone handwritten letter that I have not covered. Now you might be wondering, where did I find this? Is it something brand new? The answer is no. This letter is from 2013 and many YouTubers have covered this and it's across social media. So why am I just now finding it? Because this wasn't in Sarah Boone's case. This wasn't in her murder case. This was in her divorce case. She's trying to get money from Brian Boone and paints him in a very negative light. And I think that's very interesting, especially considering I just did a video with the body cam footage going through where she got the word protocol from. And we know Brian Boone might be a witness now for the defense. I find this very interesting that this letter exists. Now, this letter is going to be presented in small chunks like this for a very simple reason. I cannot find the full document on the internet. At some point, this was available for everyone, and at this point, it is not. My guess is maybe Sarah Boone or her lawyer have now attempted to hide this a little bit, especially if they want to use Brian Boone as a witness. But let's get into it. This was public. It is public. There's YouTube videos up on it, so we're going to cover it. Motion to read letter from respondent and schedule case management hearing. Judge Michael Dean. Judge Michael Dean is the one covering her divorce. In all my attempts, 16, to protect myself and help from the still ongoing hate, lies, slander, degradation, cruelty, and active abuse from former husband Brian C. Boone, nothing has been proved, made better, corrected, relieved in any way for myself, the respondent from former husband, the court, or judge. I have tried everything. I have made innumerable requests and sent many letters asking for aid from all, with no success or assistance, listening, or care by anyone, or other than myself, trying to relieve or altogether stop his inappropriateness, bitterness, anger, and wrongdoing. Please see list below of my letters sent to you and court per the Records Management Division of the Clerk of Courts when the third time tried getting a copy of my active dissolution of marriage agreement. I cannot have because they are waiting payment in order to receive and I am in jail. I also have no bank account after the one I had was closed after having 30 years due to non-payment of alimony from former husband stated in prior letters. So I don't have these letters, except for, I believe this is the 9-5 one. So all of those other letters, at least to me right now, are lost Sarah Boone media. Will we ever get them? I do not know. This is her claim she sent these letters. Maybe she didn't even send this many. But let's continue with the letter we do have. It is appalling how uninterested, uncaring, nonchalant you and the justice system are about my side in any of this, and will not listen without the right paperwork and attorney, knowing I am actively being taken advantage of and wrongfully mistreated by former husband Brian C. Boone. So she is in jail at the time of this due to the murder. And she is saying she is actively being mistreated by Brian C. Boone. You have continuously enabled him and given him a self-appointed right and understanding to keep doing, saying, and taking everything wrongfully and illegally from me, including and especially the love and respect from my son. It is not okay. You're a killer. That's why I'm not doing anything. Former husband said in front of my son on phone. You are not important to anyone. Former husband numerous dates. You are not priority. Former husband numerous dates. Dad says you're annoying and beg all the time. Son told me after asking him to ask former husband if he finally ordered a book and hot meal after being made to call daily to check for 13 weeks. I lie to you because I can. Dad does all the time, son. You make no difference in our lives. Former husband, numerous dates. One date the day before this letter. That's okay with you and acceptable, Judge Dean? Is that what you are giving him permission for? To keep doing and in front of my son? Why won't you stop any of his abuse, verbal, mental, and emotional? Why aren't you, as my judge, doing anything to hear, understand both sides? What else needs to be done to me by former husband in order for you to help me? What else can I do I have not done already for any relief on my side? Stop enabling. Judicially, you must know this is wrong and how I am being treated. I am told every time when trying to reduce any anguish or mistreatment from former husband and cooperate trying to help. The judge doesn't care what you write. My son now says the same when I correct him on how he is being mean and rude to me. He's never going to do anything for you until your trial is over, and even then, it will still be all in my favor. My other documents ready to go so I can take the rest. I have an attorney. You deserve nothing. You mean nothing. Then former husband gets his precious attorney to file another answer denying allegations because I'm telling the truth all the time about his awful lies and I am right. Judge Dean, so I have to continue taking former husband's abuse, neglect, unlawful actions, cruel comments, and hate? Until my trial, when it happens, however long it will be now, considering my attorney has withdrawn from my case and no date or trial is known or will be for an undetermined amount of time. Now, this is from 2023. She still has her attorney. Don't get confused. How much more hate and disrespect will former husband encourage my son to keep lying and overall being mean to me, his mother? Former husband is teaching and reflecting a terrible example of how women can and should be treated. Nonetheless, the mother of his child, this is egregious and wrong. I am requesting again, please, to schedule. It is fair, and there are too many topics to be discussed, including my attorney, to write, and I have only one pen. Necessary, lawful, active, important topics. What is the certified notice of delinquent support filed 8/3/23? Please grant my motions and schedule my imperative overdue owed meeting. Everyone needs and must have the same understanding now and future. It is fair. What else can I do? What's left except for begging, which former husband says I do all the time? What am I doing wrong in order to be treated properly? Treated properly. That's properties properly. Ethically correct in order to finally receive your judicial assistance. I still can't read her writing well. I'm sorry. This is back when she was still semi-legible, though. How I am and have been and will be treated by former husband, Brian C. Boone, is unfair, malicious, wrong, and should not be in any way allowed to continue. Stop. Please see. Please listen. Please help. Judge Dean, what was the reason for your comment made in your courtroom about former husband violating my constitutional rights? If you're not going to help or uphold said rights and lawfully allow me to use, what's the point? Why do I even have? You know I do in order for you to remark and say they are being violated. I-19-2022. So she is commenting on something from the year prior, almost a full year prior at this point. Please schedule. It is my right. It is fair. Sincerely, Sarah Boone. She also included this letter here. I'm not going to read it. It is basically a boilerplate letter from Family Law Matters saying that they aren't going to cover her. There's a second part too where she highlights part which I got these images, by the way, from Lawyer You Know. He covered it. I tried to not listen to his coverage because I wanted to read it myself for this video. But I did catch him mentioning how this is basically appears to be just boilerplate, and that the second part, which I forgot to take an image of. It's basically them saying, it's not saying that she doesn't have a case, they're just not going to do it. So, yeah. And then we have order following case management conference. This cause having come before this court for case management conference on October 16, 2023, the court having heard from all parties present finds and orders as follows. Both parties appeared for the case management conference, which includes a motion to withdraw by the respondent's counsel, Frank Fenkowitz. There were no objections to the withdrawal of respondent's counsel. Frank Bankowitz is hereby removed as counsel for the respondent. Counsel shall provide more formal proposed order for this removal to be signed by the court within 10 days. The case management conference discussed the status of the case, including the petitioner's request for reduction or elimination of alimony for relocation. And so basically, this is the court order, and Sarah Boone's lawyer was removed, from my understanding. And the petitioner, and the petitioner requests for reduction or elimination of alimony and for relocation. So, from my understanding, this is the husband saying he wants to pay her less, probably nothing because she's in jail, and wants to move the son. That would be my assumption. The respondent is currently incarcerated in the Orange County Jail pending trial on a charge of second-degree murder. The court cannot hear the respondent's motion for contempt regarding unpaid alimony until after a final hearing is held on the respondent's petition for reduction or elimination of alimony, which reversed a court's contempt order because it was issued before the modification action was heard. The respondent expressed frustration at not having matters heard and not being adequately informed about her case. The court explained that the family case is on hold pending the outcome of respondent's criminal trial. So she knows that this case is on hold until this murder trial is over, and she's still pushing it. That's probably why her letters weren't getting a response. The court finds that permanent decisions regarding relocation and alimony should be postponed until the adjudication of the respondent's criminal case so that circumstances are clearer. I will say it's a little unfair. The husband can't relocate because she's in jail, facing murder charges, and has been in jail for a while. I mean, I understand why they're doing it, but being Brian Boone, that would kind of suck, especially if you need to move for work or family or whatever. The respondent was informed that she may opt for a final hearing on the petitioner's petition for alimony reduction, elimination, or own contempt motion, but that the court would have to consider her current status of incarceration when making determinations. The respondent was advised to ensure that any motion filed conformed to the Florida Family Rules of Procedure and Florida Rules of General Practice and Judicial Administration. This includes utilizing proper captions, titles, and certificates of service. So basically, it's not valid what she was sending in. It wasn't done right. So this is interesting because I look and I believe that this is the one case on the docket that had something filed in June, I think it was. And maybe the reason that, that they're... It's hard for me to read this. And then here he's going to be a defense witness, possibly. And not think that maybe there was a deal involving the alimony or the relocation and her making a... some sort of an agreement for testimony. Now, maybe that's not the case. Maybe they're afraid people would assume that, because I do. Yeah, I just thought I would share it. Sarah Boone might be the last handwritten letter we see. What do you think?